Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
Hi, good afternoon, everyone. We are on this podcast to discuss Indian insolvency law and its way forward. I've got two very illustrious panelists on my podcast here. First, I've got Mr. James Sprayregen, who is a partner at Kirkland and Ellis, Chicago and New York office, a legendary insolvency lawyer in the US. Welcome, James. Thank you very much for being here.
Thank you.
Then I've got my managing partner, Mr. Cyril Shroff, a legend in the Indian corporate law market and a leading light of almost every subject. I'm very pleased to have you, sir. Thank you very much for your time.
Thank you.
So what we are going to talk about today is how insolvency law, as we all know, which came in India at around 2016 end, how it has performed so far, what are the learnings for the market, and what we should look at as we go along in this journey of insolvency law. We will also, since I have got two very senior practitioners here, we would also talk about what are the sort of lessons and skills for young insolvency lawyers and what they should look to learn as they become an insolvency practitioner. But let me first start with the how the IBC has done. So, Mr. Shroff, if I can come to you, we have seen a lot of frenetic activity in past few years on the insolvency side with the IBC coming in. A lot of cases have resolved, a lot of success stories. Indian banks have never been in a better health, probably in history. So the way you have experienced it so far, what will you say are the sort of key not so happy issues today in the functioning of IBC? And if you could also talk a little bit about the recent judgment in the Rainbow Papers, which talked about tax dues, that will be helpful.
No, thanks, Dhananjay. And I'm basically an optimist. So I'll start with the happy learnings first and then the not so happy learnings thereafter. So as we sit in 2023 and do a kind of a retrospective on insolvency, which kind of became an act of parliament in almost 9 years ago, and which has changed a lot of things. So taking stock, what are some of the three happy learnings? So first and foremost, I would say in terms of the recovery process, timelines have become much faster than they were pre-IBC. Earlier, what used to take a minimum of 7 to 8 years, sometimes even longer, now the average time is about 2 years, give or take. It should be faster if you follow the legislative timeline, but 2 years, when you compare it with the erstwhile 7, 8 or more years, seems like a huge relief. And the average recovery is also higher. It's 140% of the liquidation value. Whether that's a fair comparison or not is a different issue, but at least the fact that there is a positive number. And we've seen many cases where there have been recoveries which would have otherwise been either negligible or would have taken longer. So that is issue number one, basically performance. The second important happy learning is the fact that we actually have a market for corporate control. In the equity route, namely a hostile equity, open offer, etc., it's very difficult, and there's practically a non-existent market for corporate control, which perpetuates the fact that once in control, always in control. But IBC changed everything. What IBC did was through the debt route, and it came in really from the left side of the field, changed that completely, and promoters, well-entrenched promoters with significant equity holders could be thrown out under the IBC Act, and where they would lose control of the company and its control over the assets. So that's the big, and I think that has had a deep psychological impact on borrowers and just the credit market. The third obvious one, because of what I just said, is the power equation has shifted from essentially where the power was held by the debtors. The power has moved to the creditors because they're able to cause the change in control and drive the agenda. Because India adopted the creditor control model rather than the debtor in control model, which many other countries have adopted. But that changed the equation, and in a culture where there are entrenched founders and management, that was a very necessary shock to the system that was required before any real change could happen. But what I'll do is I'll take a pause, let James kind of comment, and then I'll come to the not so happy news a little later. I don't want to go on taking all the airtime first. It'll be great if we'll get James's thoughts on this, and also if he can give a comparative of what he saw in the US when their version of the bankruptcy code, namely the US bankruptcy code, came into effect almost 50 years ago. James, over to you.
First, I'm honored to be on the program with you, Cyril, a legend in not just India, but around the world. I listened to your comments with great interest. If you compare it to the U.S. Experience, you said we put in our code almost 50 years ago now, 1978. And I would say actually the experience is not dissimilar in that it took a few years for the market to actually believe it said what it said. And there was a number of things that were a little bit vague or confusing or didn't come out right. And our Congress was pretty quick at amending the new code to kind of fix the glitches, which I understand kind of happened here also. And I think that over time, really, obviously now that we're almost 50 years into it, the market very much believes in the fact that the statute says what it says. And what's happened, and apropos, Cyril, to your comments on a market for corporate control and how long cases take and creditors in control as opposed to debtors, what's evolved, and I think it's incredibly important to the market and really the economy, is our bankruptcy code gets used a lot in the United States in real Chapter 11 cases. But in my humble opinion, the real value is the very fact that we have the system and the system works, actually changes behavior at the inception of the investment process on a new deal, because there's confidence that there's a coherent, transparent process to deal with something that doesn't work. And then if the deal doesn't work out so well, the behavior of the players, the promoters and the creditors, is influenced by the fact that they know if it goes into an insolvency proceeding, here's what's going to happen. And because of that, you can actually avoid many proceedings because the behavior takes that into account and causes more proactive dealing with problems before they get to be the worst kind of problems. And I think that's incredibly positive to the development of an economy. And I always call our bankruptcy system the bottom rung of American capitalism. But you got to look up, because it's not just what happens in bankruptcy court. It's all the other things that are happening because the system exists that's positive for the economy. And I see definitely rhyming with that in what you've done.
Thank you, Mr. Sprayregen. And I think we can see some commonality between the happy experiences of these two bankruptcy laws dealing with sort of a new system. And it's interesting to see that similar problems were faced both in the US system and in the Indian system when dealing with situations of corporate distress with a new bankruptcy law. But at the same time, I would imagine that it's not all rosy. There would always be, I would say, teething issues or even issues that need resolution and are causing difficulties to players involved. So, Mr. Shroff, if I can come back to you, we spoke about the happy side, happy learnings, but what are some of the not so happy learnings? Would you say everything is perfect, or would you say there are things that we could work on?
So whilst, no, thanks for that, Dhananjay. So whilst the induction of the IBC has been a huge culture changer in the credit markets and has changed the paradigm from the pre-IBC days, there's still headroom for a lot more change, and I think there are challenges. So what are the shortcomings as we look at it? I think the first thing is one is, of course, whilst 2 years is better than the 7-8 years before, but 2 years is too long, and there are timelines which get unduly prolonged, especially when matters land up in litigation. So there is, unlike in the US, where the bankruptcy court itself sort of deals with it, we have a tribunal, the NCLT, which is a kind of equivalent, but there is a normal court system which sits above this. So a lot of cases, particularly the bigger ones, also always land up in courts, and that prolongs the timelines. So I don't think we have finally worked out the right balance between what the NCLT should do and where is the scope for judicial review, and that prolongs the timelines quite a bit. Having said that, I think there is also an issue on the infrastructure for the NCLT system. I think both the physical as well as the soft infrastructure for the NCLT leaves a lot to be desired. And they don't have only exclusive jurisdiction. They also deal with a lot of other stuff. They deal with company law stuff. They deal with competition law stuff at the NCLT level. So overall, I think the fact that all these factors impact the efficiency of what should have been a super fast regime going by the statute, where there were hard timelines that were put in. So that's topic one. The second thing, which is, call it unhappy news or call it a shortcoming, is the fact that it's not a single window. It was intended to be a single window, kind of almost like a legal magic wand, where everything could have been resolved and the asset could have been given free and clear to somebody who acquired the asset in bankruptcy. But that's not how it has happened. I think there have been huge issues with the tax department, and I think there have been huge issues with agencies such as the Enforcement Directorate, which has been unwilling to release the charges, their interests and attachments on the assets as well. So the process of handing over free and clear has been far from easy. And then there is the judicial interference as well. The most famous one being, of course, Rainbow Papers, and there was an interim judgment of Raman Ispat as well. But net, where we are today is that if there is a security interest that is created by law, and in Rainbow it was created by the Gujarat tax regime, that even post the review of Rainbow, that there is a kind of a statutory pari passu nature of security that has been created, which obviously eats into the distributable pool of assets which the secured creditors would look for. So the secured creditors have felt a little let down by the Rainbow Papers 1 and 2, and are in a position where they effectively have to share the pie with a variety of statutory creditors who have a legal security. Now, of course, it doesn't affect normal tax claims which do not have a security interest, but this is bad enough. So that's the second point. And I think the third shortcoming is the fact that we have not been able to progress the conversation on cross-border insolvency. Now, James and I are sharing this forum today on insolvency, and obviously cross-border situations should be a big part of it. But the conversation has not moved. And I think I'm looking forward to seeing when that happens, because that may provide a very interesting avenue, especially where foreign debt is involved. Interesting avenue for moving things along by trying to effectively leverage on another legal system to solve some of our infrastructure problems. So these, I think, would be headline issues of what are the shortcomings, timelines, lack of clarity on security interests, and a status quo situation on cross-border.
Thank you, Mr. Shroff. Those are certainly very topical shortcomings or areas where IBC regime needs improvement. Mrs. Sprayregen, if I can come to you and ask you a similar question, that if you look at the first, say, a decade or maybe decade and a half of the US bankruptcy code, would you say there were similar shortcomings? How did the government or the regulator react to this? And what could we do to sort of deal with some of these issues that we are talking about?
Yes, thank you. Definitely, there were shortcomings, and even today, almost 50 years into it, there continue to be some shortcomings. And I'd step back for a minute and say, Cyril started out saying he's an optimist, so he started with the positive stuff first. I would say even on the shortcomings, don't beat yourself up too much about it. I think it's virtually impossible to get it 100% right. So if you get it mostly right, you're probably doing pretty well. That doesn't mean you shouldn't try to continue to keep improving it. And apropos to that, with the US Bankruptcy Code, we've literally had hundreds of amendments to our bankruptcy code over the last 50 years in sort of fits and starts. I personally think a number of the amendments were bad amendments, not good ones. So you gotta, that's another cautionary tale to be careful what you wish for, because when you try to fix it, they don't always fix it correctly. And so hopefully if there's a fix, they actually make it better and don't have an unintended consequence. But having said that, these things take a long time to develop, and even 7-8 years is sort of the infancy, in my judgment, for a completely new system. And the types of things that you're talking about as shortcomings, Cyril, I think are all things hopefully that will be addressed in time. In particular, I think the cross-border thing, as the Indian economy continues to grow at sort of a turbocharged rate, you're going to have more and more cross-border issues over time. And so I do think that's particularly important to get addressed. The issue of how long cases take, if you talk to any creditor in the United States, even though our cases are incredibly quicker than they used to be, pre our code, they would all complain that the cases take too long. And they're not wrong. And I'd end by saying I was on a commission in the United States several years ago on how to improve our system. And we came up with a nice report, and we had about 60 recommendations, that none of which have been actually adopted by our US Congress yet. And so it really is both an element of continuous improvement, and the world changes. As your economy develops and different types of things happen in the economy, there will probably be a need for the statute to keep up. And so something that was right at one point in time doesn't necessarily stay right. So it's not a static, a dynamic situation. And that's why as lawyers, we'll always have something to do to try to be helpful and constructive.
Thank you. I'm going to change the sort of the slant of this conversation slightly. And since I've got two very experienced practitioners here, I'm going to ask something which will benefit our young listeners. Mr. Shroff, if I first come to you, how has the IBC evolved skills of the lawyers? And what makes a good insolvency lawyer? What would you say are the top 3 or 4 qualities that an insolvency lawyer needs to have?
So that is a great question. And I think what we're seeing over the last 7-8 years is the emergence of an insolvency bar. So it's a super specialized topic. And I think we will just see this theme getting stronger and stronger with the emergence of a sort of a community of lawyers, which can then be called the insolvency bar, which are specialists who do this mainly for. So from an India point of view, the emergence of an insolvency bar, whether they reside within law firms like ours or a solo practitioner, is definitely a trend for the future. A question on, okay, what skills are required? I think a variety of them, but let me boil down my top 3. First and foremost, a good insolvency lawyer needs commercial acumen. So knowledge of the law is a given, that those are table stakes. But I think the difference between a good and a not so good insolvency lawyer would be the presence of commercial acumen, because there is so much stuff that is not in the book. It's not about law, it's about how you apply the facts and what kind of instinct do you bring to resolution of matters. So that's, for example, Dhananjay, you yourself, you worked on some cases which did not have a precedent. So you commercially sort of borrowed examples from the globe and applied them successfully in India as well. So I call that both commercial acumen and creative thinking. That's one. The second, I would say, is that one needs a good insolvency lawyer needs to be essentially a generalist, or maybe a bit of both, a generalist with specialist skills. You need a broad skill set because you, on a given day, you might have to deal with real estate issues, you might have to deal with litigation, you might have to deal with IP issues, tax issues. It's almost like the last bastion of a generalist to be an insolvency lawyer, because you're essentially dealing with the tail end of a company's life, and in a company's life, all sorts of problems and all sorts of situations would have come to be. So it's only a generalist who can kind of tie all the loose ends together and bring it to a happy landing. Happy, unhappy, whatever it is, but somebody who can understand all the nuances. If you had a unidimensional approach, you would only see one side of the problem and miss the elephant. And I think the third part of it, I think, is the third criteria for a good insolvency lawyer is also to build consensus amongst the various stakeholders. So one of the great realizations in an insolvency is how many stakeholders there actually are. You have the erstwhile management, you have counterparties to commercial contracts, you have lenders, you have employees, you have tax authorities, there are endless number of interests which kind of come to play, and there is, by definition, there is a shortfall. So everybody is trying to maximize their recovery from a limited pool, and that requires somebody who can make the trade-offs and is a good negotiator between the various stakeholders. So this would be my 2 bits on what it takes to be a good insolvency practitioner. But I'd love to get James's views.
Yeah, it's interesting. I would say you even used some of the lines I've used for years in the United States. It's kind of, I think, similar around the world. There's no question that deep substantive expertise is the minimum table stakes. So that's where you need to start with whatever the obviously the bankruptcy statute here, but probably, as you said, there's every case is different and it depends on what the problem at hand is. So it is the last bastion of the generalist. So then you need to learn whatever the specific issues are, legal issues in a particular case. So to me, that's just the minimum. That's how you get in the door. Then I'm always a big fan of saying, don't tell me just what the problem is, tell me what the solution is. And so it's the easiest thing in the world to spot the 10 problems why something can't get done. So I've always told the younger lawyers when they come to me, tell me the solution too, or at least, your suggested solution, and then we can work on it. Don't just be a problem spotter. So to me, that's important. And I couldn't agree more on your point about, commercial acumen. It's the insolvency world, the restructuring world is about as close to being a businessman you can come and still be a lawyer. And so you really got to take into account the business aspects involved in what you're trying to accomplish. And again, sometimes I found the instincts of younger lawyers is to try to get the risk level down to zero. The risk level is never zero. The question is identifying all the risks, dealing with them as best as possible, and then making a judgment call as to how you move forward in the face of the fact that there's always some risk. You paralyze yourself if you think that you're trying to get risk level down to zero. And I call that getting comfortable in a world of ambiguity and chaos, because you never have all the answers and you still need to make decisions. And you got to learn to get comfortable in that kind of world. And then your point about building consensus, again, I couldn't agree more with. And that's sort of, EQ skills more than IQ skills. And that's really important in dealing with people and bringing people together. It's the old, you can disagree without being disagreeable. And I found over the years, I've made some of my best friends from people I've met across the table in deals. And those relationships over time really hold you in good stead in not just having friends, but in whatever number of deals you do, having a trusting relationship and a way to get things done. And I think that's, again, part of the value of the development of the ecosystem of an insolvency bar, I think it actually provides efficiencies for an economy to be able to get those things done. And then the last thing I'd say is God gave you 2 ears and 1 mouth for a reason. Listen. You can do an incredible amount by listening rather than talking, and both because you learn a lot, and often the person doing the talking is giving up a lot of things that they shouldn't be giving up. And if you're not talking, you're listening to those things. So listening is an incredibly important skill, and sometimes it's hard to sit there and not talk. Resist the urge.
It's great advice, James.
Thank you. Thank you very much to both of you. This was a great session, and I'm hoping the people listening to this will be able to learn a lot from this. Thank you very much. That's all the time we have today. I'm Dhananjay Kumar. I'm a partner at Cyril Merchant. Thank you very much. Bye.
Thank you.
Thank you, James. Great episode.